I'm delighted and privileged to be joined today by Matt Campbell. Matt is the brother of Geoff Campbell. Geoff was killed in 9/11 in World Trade Center. His inquest was held in the UK along with 9 other victims in 2013. The inquest lasted about an hour and a half, with 3 minutes devoted to Geoff. And the cause of death was found as follows. At 8:46 a.m. on 11th September 2001, the deceased was on the 106th floor of the North Tower of the World Trade Center when an aircraft, American Airlines Flight 11, was deliberately flown into the building, causing its collapse at 10:28 a.m. The event was part of a coordinated attack by the Islamist militant group Al-Qaeda. Now, Matt and his family are fighting that decision, and they want the inquest reopened. They've had 2 goes at this. They've had 2 attempts at getting the inquest reopened. Both have been denied, and Matt's joining me today to discuss the case and the response from the British government. Matt, welcome.
Thanks, David. Looking forward to chatting about everything.
I'd like to start, if I may, with the first appeal you made for a second inquest. Could you just outline the sort of case you'd made, the evidence you'd collated, and what was the response of the legal authorities in the UK?
Yeah, so I mean, the initial application, if that's what you're referring to, went in way back in August 2021. It was a 2,500 page application where we had expert testimony. We had eyewitnesses, that's from first responders, including a police officer who was there on the day, witness to explosives and explosions, etc. We had evidence from the experts detailing whether it be physics evidence or chemical evidence, and it was a very comprehensive bundle. We made arguments as to why there was no inquiry into my brother's death, and we were fairly confident because we've got this mechanism called the Section 13 of the 1988 Coroners Act, and you are able to petition the Attorney General to get a new inquest opened if you can put forward grounds of insufficiency of inquiry or new evidence that wasn't considered or wasn't put in front of the coroner. So, it took a long time to put that together. It was probably about a year's work. And, we were confident that, okay, when the Attorney General would get back to us, it would be a positive decision. And we waited and we waited, and we had a little bit of communication backwards and forwards. We ended up getting more documents that we hadn't seen, which actually further strengthened our case. We managed to get hold of a counter-terrorism report that had been withheld from me when I tried to get it, but because we were engaged in the legal process and I had a barrister representing us as a family, we were able to obtain that document, and other things came out. But 22 months later, which to me is astonishing, they came back in June last year and flatly refused permission, which was obviously disappointing, but I think it was more in the manner in which they did it. I mean, it was clear they hadn't looked at anything in the application. They really didn't apply any legal tests that they're supposed to when making a decision, and we felt like it had just basically been dismissed out of hand. I mean, essentially we thought it was unlawful and it was irrational, and so that was the first decision that we had back in June. We have a process in England and Wales whereby within 3 months you can challenge an official decision, in this case made by the Attorney General or the Solicitor General, and you have to go through something called judicial review, which is expensive, and it's really arguing law rather than actually what we're trying to do, which is get evidence into a court in front of a coroner as to how my brother died. But anyway, we had to go down this route, and we managed to raise the funds, the significant funds, last summer through crowdfunding, and we prepared the judicial route. What the barrister did, it was substantive grounds. We, oddly enough, submitted that on the 11th September. We were pushing it to the wire. I think we had until something like the 26th to actually file and apply for judicial review. But as it happened, amazingly, a few days before the deadline, the Attorney General backed down. They withdrew their unlawful, irrational decision that they had made in June. Basically, it's a tacit admission that they were going to lose. But absolutely, we felt we had a strong case, and they clearly thought so, because they just basically said, right, we withdraw our decision. And then within their rights, they're allowed to make a fresh decision, which is frustrating. And so, we're now talking early October, and we waited. And, they kind of, it hinted that it would be made, reasonably quickly. And then November came, and then December. And then the beginning of this year, we had a second response from them. And again, they have denied our application to reopen my brother's inquest.
Yes. So, I mean, I've read your family's press release, which is excellent. It's really informative and very specific, and I think makes the case extremely well. So I'm going to quote sections of this because I'd like to discuss it in more detail with you. But it's a very good summary around which we can construct our discussions today. So it starts off. The heading is "Family of 9/11 Victim Vows to Keep Fighting for a New Inquest After UK Attorney General Denies him a Second Time." And it starts, "We are saddened to announce that for the second time, the Solicitor General for England and Wales, acting on behalf of the Attorney General for England and Wales, has refused our application for a fresh inquest into the death of our beloved son and brother, Geoff Thomas Campbell, on September 11, 2001. It goes on, "The Attorney General's first decision, issued in June last year, was so legally indefensible that a letter notifying her of our intention to seek judicial review and our statement of facts and grounds compelled the Solicitor General to withdraw that decision last September. Turns out that the Solicitor General withdrew the decision not for the purpose of conducting a more thorough, objective and legally sound review of our application, but rather for the purpose of concocting a new set of rationales for denying the application." So this goes to the integrity of the people making the decision. I think we should talk a little bit about the people at this point. So you're dealing with two people. You're dealing with the Solicitor General, Robert Courts, KCMP, and the Right Honourable Victoria Prentice, KCMP, the Attorney General. Have either of these people met with you and your family?
No. It's all been conducted through the barrister and only in writing.
Right, okay. I see that Robert Courts, KC, his career before politics he was a barrister involved in personal injury and clinical negligence, so not tremendously relevant, although it is in the law. And Victoria Prentice actually has very relevant experience. So she was a lawyer for the Treasury Solicitors Department and headed the government's Justice and Security team. Her responsibilities included providing advice on military, prisons and national security matters and representing the government in court. So although very much a government person, there's no excuse in terms of her knowledge and experience, because it's very relevant, and we'll get to the lack of rationality in the government's case in a moment. But there doesn't seem to be any reason in terms of inexperience or in terms of not being fit for the job to excuse a wrong decision. And it seems to be that you're in a position, which crops up so very often these days, where you're having to persuade someone of facts where their salary depends upon them not being persuaded. And this is a huge uphill struggle. I mean, do you have any sense of what you're up against in terms of the psychological response of the government side? Have you had any insight into how they're treating your case?
I mean, I don't know about insight. I mean, all you can see is what they are doing and what they should be doing. I mean, it's what they should be doing is looking at our application very objectively. That's what they're supposed to do. They're supposed to apply the law, and that in theory is how the system's supposed to work. I think it's rather unfortunate that they are elected, or certainly the Attorney General is an elected member of Parliament. I don't think it should be political at all. It should be just a legal issue. But for me, why are they denying something that, in conversations with the barrister, it's very obvious that we are so far above the normal threshold of what would be required in terms of what is new evidence. I mean, he actually sits as an assistant coroner, and he has various other roles as well as being a barrister. He has a lot of experience in inquest. The threshold is so low, and yet we are so way above that. So it does beg the question: why? What are they scared of? Why aren't they letting this go through and following its natural course, which should be they give permission, it goes up to the High Court. The High Court, in general, reflects what the Attorney General's decision is, which is they would quash the 2013 inquest and reopen a new inquest and assign it back to the West London Coroner's Court. I can only hazard a guess that they are so scared of, in particular, a family member opening a can of worms by essentially challenging an official narrative in a court of law, and I think they're petrified of allowing that to happen. And so they're doing everything they can in the lawfare war book, to basically make it extremely hard for us. And that's what I see them doing at the moment.
I mean, the implications of opening up a new inquest is obviously very frightening, given the fact that there have been wars and government policy and many deaths, and everything is based on the official narrative. And to allow that to be doubted, I mean, I can see why they're frightened. But of course, their job is not to be frightened. Their job is to actually adjudicate the law. So your press release goes on. It says, our case for a fresh inquest is made on two separate grounds. The first is insufficiency of the inquiry at the first inquest. The second is the existence of new evidence not heard at the first inquest. Under the law, a fresh inquest must be ordered if either ground is satisfied. So it then goes on. In response to our claim that there was insufficiency of inquiry, the Attorney General's new decision asserts that it was reasonable for the coroner to rely on the evidence presented by the Metropolitan Police. This evidence included 2 pages of narrative summary of the events of the day, 1 page of information about Geoff, and a brief testimony at the perfunctory 99-minute inquest held for 10 British 9/11 victims on January 29th, 2013. Where only 3 minutes were dedicated to Geoff. So this is right, inadequacy of information. Okay, 2 pages of narrative was it. I find it difficult to see how they can defend that was adequate. I struggle with what's the case there, and they're claiming that was adequate. Essentially, is it that the facts are known, every right-thinking person believes the official narrative, therefore we're fine? I mean, is it as arrogant and disconnected from legal process as that? I mean,
yeah, I mean, they've obviously come back twice now and said no. So the first time was just ludicrous in terms of the insufficiency of inquiry. They deferred to the to 2 reports that we now know, because we got that police report, were summarised into those 2 or 3 pages. They referred to, the 9/11 Commission report, which does not at all look into how the towers came down, and certainly not specifically how my brother died. They also referred to an FBI investigation. And again, we have all the documents that were put in front of the coroner. There is a single page in that police report from the FBI investigation, and that's only to do with Zacharias Masui and his trial, which has absolutely no bearing on anything to do with my brother's death and certainly causation. It's, and then again, the second denial, they try to make it sound a little bit more exciting by saying under Operation Exchange, the Met carried out an investigation. Like I said, this police report is, as we just described in that press release, it's a couple of pages. It's cut and paste. It's American spelling. It's pretty much American grammar. It's just cut and paste. There's no real investigation. And the one page into my brother's life and death, effectively summarized there, it's referring to stuff that they've gleaned from us as a family. And that's it. And like I said, that was briefly covered in 3 minutes. That we know there was nothing placed in front of the coroner to even attempt to try and establish the cause of death. Not just my brother, but the other victims as well. There is no defence. It seems crazy that they can actually still come up with this in their response letter for grounds for refusal. That they rely on this amazing sounding Operation Exchange report. And they basically said the same thing. They're just repeating bits of the official narrative, but again, it has no bearing whatsoever on how my brother died.
Yeah. So this seems to be a very weak position. Now, the other half of this, your press release continues. It says, as for the response to a claim that there is new evidence not heard at the first inquest, the Attorney General's new decision abandons the demonstrably irrational reasoning set forth in his first decision and now relies on the sweeping, unsubstantiated assertion that the evidence we presented in our 2,500-page application is, quote, not credible. Okay, so this is very much the core of their argument. It must be, as we've said, it must be in accordance with the official narrative, not because reason, not because of the law, not because of engineering or physics or evidence or anything. It must be as the official narrative because if it's not, the alternatives are simply unthinkable from their point of view. And therefore, anyone who says differently is not credible, because credibility and truthfulness and evidence is now being confused with convenience and ease. This is they're not using the words as they are in the dictionary. They're defining things out with their narrative, I suspect, as being intellectually beyond the pale. So you get these dismissive words, and it's all the way through this. I'll quote from other bits shortly for the actual Attorney General's letter. The language is strange. It's not precise. It's not legalistic. It's not technical. It's sweeping, and it's dismissive, and it's conjuring up an emotional response, not a painstaking legal argument. It's a very strange performance from them all around. So they go on and says, your press statement goes on, the Solicitor General's only basis for this assertion, right? So the assertion is that if everything you've said is not credible, all 2,500 pages, is to cite the reports issued by the United States National Institute of Standards and Technology, NIST, and to claim falsely that they represent, quote, the clear consensus view on the cause of the Twin Towers collapse. And your team continued, first, neither the NIST reports represent a consensus. Sorry, beg your pardon. First, whether the NIST reports represent a consensus view is irrelevant to a correct application of the law. Point. Second, new evidence that contradicts the conclusions of the government's report cannot be rendered not credible merely by the existence of that report. History is rife with examples of government reports later being proven wrong. So these are very strong points. I would add a third one. My background, when I'm not doing things like this, I'm a structural engineer. I'm a chartered structural engineer and fellow of the Institute. And the NIST report doesn't describe the collapse of the buildings. The NIST report stops at initiation of collapse and basically says, progressive collapse then occurred. And there's no discussion in the NIST report of how that happened. And one of the biggest concerns that people like 9/11, 9/11 Truth, the engineers and architects who are questioning the official narrative, have is the lack of credibility of the collapse mechanism claimed. So it's not even true to say that that the NIST report defined the cause of the collapse. The NIST report claimed to define the initiation point of the collapse and then just said, and well, you saw what happened after that. It didn't actually go into this. So have you had any feedback, any more specific feedback on these issues about the adequacy of the NIST reports? Have they actually tried to engage with you on the substantive matters here?
No, I mean, we've just had this, the response, and like I said, we are, at the moment fundraising to basically go through the process of judicial review, and obviously these are things that a barrister would have to address. I mean, the situation with them citing the NIST reports it's infuriating because again, it was something that was not put in front of the coroner, in the first place, and as you correctly pointed out, they only went up to collapse initiation. So it doesn't even cover the cause of my brother's death, the cause of the building's collapse, and how that actually happened, and how that actually played out. And then they just use this phrase "not credible." But I mean, in the actual response from them, they go on in the next paragraph to basically say that they're not going to instruct their own experts to look at our evidence. So they're just saying it's not credible, deferring to an official report which wasn't in front of the coroner and doesn't actually cover the causation of how my brother came about his death, how the building collapsed.
Language. This is exactly right. So the next paragraph reads, furthermore, the Solicitor General admits he did not conduct a substantive review of the new evidence. The decision states, quote, the solicitor does not consider this case justifies the instruction of his own experts to address the expert evidence. So the Solicitor General may be expert in the law. Let's hope he is. But he's not a structural engineer. He's not got any relevant technical ability to assess that sort of evidence. He's not a fireman. He's not. I mean, a lot of the evidence you've got is eyewitness, I understand. We'll come to that in a moment. But he's decided that the evidence doesn't justify appointing experts to assess the evidence where he's not capable of assessing the evidence. This is a really remarkable position for any law officer to take. It seems just asking to get overturned.
Yeah, I mean, you would have thought after my dad said that the first denial we had, it was almost like someone had rushed their homework. The wording was poorly. It was just, it looked like a very rough draft by someone who hadn't even done first year at law school. It was that poor. And this is just more of the same. It is ridiculous that they can actually, with a straight face, say that they're not going to instruct their own experts. I mean, is it reasonable for them to do that? Yes, it is, but in particular, if they're going to refuse it on the grounds that they think our evidence isn't credible. So, like I said, the threshold we're at is way above what would normally be required
I,
to reopen a new inquest.
I don't see how they can say the evidence isn't credible and simultaneously say, and we've not had anyone on our side who's competent to consider the evidence. Right? You know, I don't see how those two statements can
Well,
both be true.
it's irrational. That's the irrational part of well, many parts of the responses they're giving us are irrational, and the skill of the barrister is to basically argue why they are making an arse of themselves, like they did in that first response. It's different. They're using slightly different language, but it's the same thing. They're not giving reasons as to why something isn't credible. They're not giving reasons as to why they're refusing, which they're supposed to do. They have a duty, if they're going to address our, and refuse our application, to give reasons why, and they haven't. They're just, swerving the whole situation, hoping that
it gets worse. So your press statement continues. In an attempt to justify summarily dismissing the new evidence, the decision states that the Solicitor General was, quote, unable to conceive what additional benefit Al Qaeda or indeed any other malign actor could gain by planting explosives. Right, there's more. It actually gets worse again, but I'll pause there for a moment. So, the government's position. I don't want to laugh, but the government's position is there was an Islamist terror attack in, I think it was '93, where bombs were placed inside the building to bring the buildings down, and that's in the historic record. And yet the Solicitor General cannot conceive of what benefit Al Qaeda could possibly have from planting bombs in the building. Again, I find that, I mean, it seems to be based on the assumption that you will never get a fair hearing. Because if there's a fair hearing, that level of argumentation surely must lose, because it's transparently hopeless.
I mean, it's such a ludicrous position or statement for them to come out with, because I mean, if a terror attack, the whole point of that is to create terror, and that was obviously useful to then respond with the war on terror. Terrorist attacks are rife with secondary explosives, and more than one attack. You might have one explosion, you then followed by a second one when the first responders go in, or you've misdirected people to where they thought they would be safe, etc. And yeah, as you say, it's well documented, the bombing, the first attempted bombing of the World Trade Center in '93. There are, oh God, I think Ramzi Youssef, who got done for the 1993 bombing, is on record with an FBI agent saying, with a little bit more money and better placement of the explosives, they would have knocked down the towers. As late as '99, one of the blind sheiks, sort of right-hand man, was still trying to get hold of the blueprints for the World Trade Center. This idea that they don't want to, when they talk about Al Qaeda or other malignant actors, but it's like this idea that they wouldn't want to plant explosives and bring down the towers, being fanciful, is just ridiculous. Yeah. Of course, that's what you want to do if you really want to create terror and to do what they wanted to do, whoever it is. You want to create maximum mayhem and death and destruction. So,
well, I said it gets worse. So you used the word that they used, and it does get worse, right? So having based their reasoning on their inability to conceive of an Islamic terror organization doing what we know historically an Islamic terror organization did 7 years previously, okay? Based on that reasoning, they then said, it therefore considers that the hypothesis we advance is fanciful, right? Quote marks fanciful. That's the word that the Attorney General used, Solicitor General. Fanciful, Right. Now, this is not legal language. This is not technical language. This is not arguing a case. This is trying to create an atmosphere where you are silenced. Right? This is not what courts are for. Courts are for allowing people to have their say and allowing the evidence to be examined, and and issues and concerns to be resolved. This is the sort of language that you see in politics and in the culture war, where one side is seeking to shout down and silence the other and make them feel embarrassed or ashamed of their opinions to try and eliminate the opposition. It's political language, or it's manipulative language. It's not legal language. I find it amazing that that's cropping up here. The Solicitor General, you go on, your team goes on. Solicitor General is apparently oblivious to the known use of secondary explosive devices, she said, in terrorist attacks, and to the documented intent of Al Qaeda operatives to destroy the Twin Towers. He illogically fails to consider the reasonable premise that the terrorists would seek to inflict maximum death, damage, and terror. Ultimately, the Solicitor General's cursory dismissal of the new evidence is a gross misapplication of the law. For a fresh inquest to be ordered on the grounds of new evidence, the law merely requires that we want the fresh inquest and that the new evidence exists. The perceived ability of that evidence to alter the conclusion of the first inquest is irrelevant, because otherwise you'd be having an inquest to decide if you want an inquest. The only question that he can be answering is there new evidence? And you put in 2,500 pages that weren't in the 2 pages that constituted the original evidence. So it seems to be new to me. And you conclude, after the first decision was drawn, we expected the Attorney General to correctly apply the law the second time around. Her failure to do so the second time is beyond negligence. It's a cruel obstruction of a rightful pursuit of the truth about Geoff's murder. So this is where you're at. You're being obstructive. And I think that's quite clear. And the person most directly responsible is the Right Honourable Victoria Prentice, KCMP, ably assisted by Robert Coates, KCMP. So if anyone's watching this and wants to, write to these people to say that they should be reversing this decision, I think that wouldn't hurt if they see that there is public support for your position. But it does seem to be, outright obstruction. So could you tell me where your campaign is? How are you going about dealing with that? You've formed a body of evidence, you've taken it to the authorities, and what you're getting is obstruction. What's your next move?
Yeah, so I mean, like I said, our only option at the moment is applying to the High Court for judicial review, which I said you have to do within 3 months, which means our drop dead date for filing is the 3rd of April. But obviously we need to raise the funds, and the barrister actually needs to do the work beforehand, before that, obviously, that deadline approaches. As part of the judicial review process, which is what we obviously did last September, there's a thing called a pre-application protocol, which is effectively this letter where you fire a warning shot to the party that you're going to litigate against, essentially getting them to come to their senses, which we did, but we didn't just send a letter, it was the full substantive grounds. And I think it was just so hard hitting, they knew they would definitely lose should that actually go into court. And so we're going to do the same again this time round. But like I said, it's not, judicial review is probably one of the most expensive things to do. It's a mixture of arguing you're just making legal arguments about how the law works, as well as obviously addressing whatever your application was in the first place. And so at the moment, I think we're only about a fifth of the way through, a little bit more than that, because the work is actually broken up into 2 tranches. But we're trying to raise £60,000, and we've got until well, really the end of the first week in March. So we're up against it. It's been fantastic so far. What people have donated, and we're just hopeful that we can get into a position where we can at least do that. Firing off the warning shot to the Attorney General, because I can't see how they can win this. I mean, it's so frustrating. And I said it's part of lawfare. They know they try to exhaust you energy-wise, time-wise, and more importantly, money. So that's their tactic, and the actual content of the letter is it's ridiculous. But that doesn't matter to them. They know we have to go through that judicial review process. So it's a great technique for them to employ. So yeah, our only route is this judicial review. So if the 3rd of April comes and goes, we cannot effectively appeal or apply for this judicial review at the High Court on the decision that they've made in January this year.
I've got the Attorney General's actual letter here, and it is actually worse than your press release summary of it. A couple of bits I'd just like to talk through. So the main conclusion: in order to grant permission for your application to proceed to the High Court, the solicitor must be satisfied there's a reasonable prospect that the court will order a new inquest. Having considered the application, the solicitor is still of the view that the test has not been met. And this gets to the how do you convince someone of a fact if his salary relies on him not being convinced of the fact, right? Because I'm sure that the Solicitor General realises that granting you a new inquest would be huge news and possible political suicide, and maybe he doesn't feel like doing that. Of course, his job is to do the right thing and the legal, lawful thing, not to further his own career. So they go on at some length. I'll read a couple of paragraphs because it's very bad and it's just worth highlighting. So this is from the Attorney General's office. The application alleged that the original inquest was deficient on grounds of insufficiency of inquiry and the discovery of fresh evidence. The solicitor does not consider these grounds to be made out. The events leading up to the attack on the World Trade Center was thoroughly investigated by the FBI and the National Commission on Terrorist Attacks in the United States. The conclusions of these investigations are widely known and accepted. So again, it's all painting a picture that all right-thinking people believe this. They were summarised at the original inquest by Detective Inspector Howard Way, who gave evidence on the events leading up to the attacks in his 2 pages, and the Metropolitan Police investigation with the code name Operation Exchange. It was reasonable for the coroner to rely on this evidence, which concluded the attack on the Twin Towers was part of a coordinated attack using hijacked passenger planes by Islamic terror group Al-Qaeda, which over 3,000 people lost their lives. So that's restating the official story. All right. It then continues. Furthermore, the solicitor does not consider that the expert and eyewitness evidence about pre-planted explosives, would make a meaningful difference to the verdict because it is not credible. So all of the eyewitnesses are now not credible. Not been tested in court, but somehow I don't get how that is. How is that not? Sentence first, trial later? Is that not that they're coming to the conclusion now? And having come to the conclusion, you don't get to make the case. They then say the structural cause of the collapse was subject to detailed investigation by the National Institute of Standards and Technology, NIST, in 2005 and 2008. NIST published reports titled Federal Building and Fire Safety Investigation of the World Trade Center Disaster, final report of the National Construction Safety Team on the collapse of the World Trade Center Tower. The reports, which are available online, described how impacts from aircraft and subsequent fires caused the collapse of towers and made recommendations for increased structural integrity in future. Now, a couple of points about this. I'm an engineer, right? I'm coming at this from a structural engineering perspective. It is true that they made recommendations for increased structural integrity, right? Integrity meaning robustness, the ability to resist damage. It is not true that anything was done to the American building codes to do anything to improve structural integrity. And the reason that nothing was done is there wasn't a problem. Now, I had an interesting experience some years ago because I share a name with another engineer with whom I've been confused in the past because we used to work for the same company. And I used to get some of his library books. And at the time he was working in an earthquake engineering zone and I was working in Glasgow, and I got all these books sent to me on earthquake engineering. So no, that's the other David Scott. So it transpired he ended up having a career in America, working on high-rise buildings. And I made some statements publicly about the need for a new investigation into 9/11 on technical and engineering grounds. And all of his mates thought it was him. And he got a bit of flack. So he phoned me one night to sort me out. And so this call came in from America, and we started off, and I described how robust the Twin Towers were. I said, these are fantastically robust buildings. You can cut all the columns all along one side, all the way along, and round the corners, and it will still stand, and it will still resist a hurricane in that condition. And he agreed. This is someone on the other side of the argument. He agreed that's how robust it was. These are phenomenally robust buildings. So the idea, I just point out that the assertion that, or the suggestion that comes from this, that the buildings were somehow defective, lacking robustness, lacking structural integrity, is false. It's technically false. And it annoys me to see lies like that used to obstruct you and your family from seeking a proper hearing of the evidence. So they continue, the solicitor does not consider the case justifies the instruction of his own experts to address the expert evidence relied on by the applicant. So he's made all these statements, but there's no understanding behind it. I'm just believing the official story, and I'm not going to check, because if I don't ask any of the questions about, for example, how did the collapse happen, then I won't be embarrassed with any of the answers. They then use the fanciful statement, right? So it's another paragraph. One more, and I'll get your comment on this. You must have been very disheartened and angry when you saw this come in. Finally, the solicitor was unable to conceive what additional benefit Al-Qaeda or indeed any other malignant actor would gain by planting explosives in the basement as well as flying planes into the Twin Towers. On a common sense view, the solicitor considers the hypothesis advanced by the applicant to be fanciful, and therefore unable to discredit the consensus view on what caused the collapse of the Twin Towers. So this whole position is, we've already made a decision, and we're not going to challenge it, and we're not going to look at evidence that does challenge it, and we don't like you if you do. That seems to be it.
Yeah, I mean the language is peculiar. They're just avoid engaging with our evidence. I think that's the key thing that's very obvious from their response. Because they know that's going to cause problems for them. And that's why I think specifically in their responses, they haven't addressed any of the evidence that they put in, because they know that's going to be problematic, because we can tear them to pieces over what they criticize in terms of the evidence that we put forward. It's very frustrating. And a point you touched on earlier, where you were talking about the eyewitnesses, and just dismissing them out of hand as not being credible. These are people who, the late Graham McQueen did a lot of research on this, and he went through these statements that were taken in the days and weeks after the attacks. And, these were statements freely given by first responders. So you've got, a mixture of police officers, firefighters, medics, etc., who they weren't prompted they weren't given any suggestions. Or did you hear explosives? Did you this? They actually just wrote a statement of what they experienced that day. And out of the some 450 odd witness statements that were taken that are on record, 150, at least 150 of them are talking about explosives, flashes, bombs, etc. To dismiss those out of hand, and we're talking like 20, whatever we are now, 23 years on. At the time of the application, it was 20 years. They're still willing to go into a court of law on oath, talk about their experiences that day and what they were eyewitnesses to. And so, they are refusing to engage with our evidence. And one of those things they mentioned there, I won't highlight it, but specifically, I know that they are only referring to perhaps an easy, accessible, short letter that someone wrote in support, rather than actually digging into the 2,500 page application, because that's way too hard for them to comprehend. They're just refusing to engage, and by refusing to engage and by refusing to give any specific reasons as to why our evidence isn't credible, they're doing that because they know we will pull them to pieces should they do that, and that's why they've avoided it, and that's why they've used this language of fanciful and not credible, without backing it up with anything, which is what you would expect to do. They're in the legal profession. That's what they should be doing, applying the legal test. Here's reasons why. Boom, boom, boom. And they haven't.
So could you tell us a little more about the evidence basis? Because you had eyewitness, you also had expert testimony. Could you just run through the sort of range of evidence that you included in 2,500 pages?
Actually, probably have my list with me. I'm not the best person to ask, because I sort of forget these sort of things. But I mean, essentially, there's evidence of explosives and incendiaries that's in the actual dust. We've got just physics and measurements of the way that the towers came down that aren't something you'd expect if this was a progressive collapse caused by fire. You've got the constant acceleration of the North Tower for about 4 seconds. It just can't be doing that and still doing work and destroying stuff underneath. It just doesn't work that way. The eyewitness statements, like I said, to say they're not credible is disgusting. And I think we had either 5 or 6 eyewitnesses. I said out of 150, obviously not everyone's still alive. We couldn't get hold of everyone who made those statements, but there are probably more, and we are still looking to see if we can build the case. Because once, not build the case, but get more evidence in, because we have that opportunity should we actually get this into court. But the application as it stands, we had, I think, 6 expert eyewitness statements. So these are physicists, chemistry experts, etc., all putting things down in a statement that they've basically sworn is true, and backed up with all sorts of evidence, be it video evidence, like I said, or analysis of the dust, etc. It's to just say it's not credible and to dismiss it out of hand is just, it's not right, and they are avoiding engaging with it.
I have here the crowdfunder page, help reopen Geoff Campbell's inquest. So anyone watching who can make a contribution to support that, please do.
I mean, the link there, David, sorry. I mean, just so there's 2 ways that people can find that. So that's you're doing it through a crowdfunder website in the UK. Yeah. But the easiest way to find the link is if you go to ic911.org. That's the International Centre of 9/11 Justice. That's ic911.org. There's a link there to the crowdfunder website.
Okay. So your family's been at this now for some time. You've been fighting this now. I mean, in terms of an active fight, how long has this been since you started to actually take action? How long has the fight been going on?
I mean, for me, just in terms of questioning the official narrative, that started for me end of October 2001.
Oh, right, okay.
There was an article by John Pilger, the late John Pilger, called "This War is a Farce," and it just, I think Americans and the Brits had just started bombing in Afghanistan. He, just looked at the fact that 15 out of the 19 alleged hijackers were Saudi. Most of them had done their training either in the US or or elsewhere. It's just, and at the end it sort of said, it was a comment by a dad who'd lost his son. And it just, this is being done in my son's name, and that really got me just thinking about what the response was. Would be, okay, who was involved, what actually went on. I initially was more focused on, I guess you could call it, intelligence failures, the hijackers, and all the supporting stories and backdrop to that. I only really took interest, I guess, about how the towers collapsed, and obviously ultimately what killed my brother, probably around the time that the Building 7 report came out in 2007, 2008, I can't remember exactly. But in terms of, this fight that I'm doing now, so I said the inquest was 11 years ago. And, for reasons that are kind of understandable, it was adjourned from 2004, these 10 separate inquiries into 10 individuals that had died. And, the reason being is there's supposed to be opportunity to do further investigation and, whatever they're supposed to do. So when we finally had the inquest in 2013, I mean, apart from the fact, this is how thorough they were, they ignored remains of my brother that had been identified in 2008. They weren't cited at the inquest. So actually, they didn't do a lot of investigation in the years from 2004 to 2013. But anyway, they had the inquest. It was so far on for a lot of families. Only 2 of the victims were represented at the inquest. I didn't go. I was in a really kind of angry stage at the time. I just said to my mum, let's not go because we'll, upset proceedings, etc. And I'm glad I didn't, in a way, because I didn't have any of the way that you should be approaching this, or evidence that could have been submitted at the time. I wasn't in a place to do that. 2014, I just basically started to think about, okay, this inquest needs to be reopened because they didn't look at any of the evidence, particularly of the use of explosives, etc. I didn't know at the time how little investigation they'd done into anyone's death, let alone my brother's. And I mean, for a long time, I couldn't get hold of that police report. It was labelled exempt from disclosure. And like I said, it was only through the legal mechanism in the last few years did we actually manage to get hold of this magic report. But yeah, I mean, so, I think I started actively seeking information from the coroner's court in late 2014. And really 2015, I started thinking, okay, what needs to be done? I did a small crowdfunder just to test the water with a barrister, the same barrister I'm with now. And it became very clear at that point. It's like, okay, there's tons more work, tons more money needed, and loads more preparation needed to prepare, in order to reopen this, my brother's inquest. And it's just been a long period of time, 23 years on, but, in particular, last 11 years are frustrating.
Yeah, I mean, I saw decades in fighting and assembling the case, and this is often the way where people have to fight official injustice. If you look at the Hillsborough families, if you look at the post office case that's come recently to the fore, and several cases that I'm working with in Scotland, where the state's conduct is so egregious that most of the time they simply refuse to answer a question because there's no defence, and people have been going 10 or 20 years in the fight for justice, and this is how it operates. It exhausts people, and the fact that you're still there is to your credit, your family's credit, that you're not going away and you're continuing to ask questions, and they're continuing to not have answers. So I wish you all the very best with that, and I'll watch carefully for any developments and any court time you eventually get. And I wish you every success if you get this to judicial review. I'm sure your barrister will have a rare old time with the government barrister trying to defend that position. And it's a case of as soon as it gets before a court that's not already made a decision, it's just getting it in front of any sort of tribunal anywhere that will actually look at the evidence. That's the key, and that's the difficulty, and that's the barriers that have been placed in front of you. And that's not what the courts are for, and it's not what the Attorney General's for, and it's not what the Solicitor General's for. They're not there to bar you from justice. They should be doing the reverse, and it's very sad to see them behaving in this way. And we've seen this a lot. We've seen it through COVID. We've seen it through a whole lot of things where the position of let's look at the facts, let's look at the data, let's approach this reasonably and with meticulous attention to detail, and let's determine to the best of our human ability what the truth is. That's gone. That's not any longer part of the mainstream in politics or the mainstream even in the law. Right? I think the law has deteriorated quite considerably. Instead, it's let us determine what is an acceptable thing to say, and let's say the thing that is popular or favoured, and that becomes what our nation is built on. And if our nation is built on that, it's built on sand, and the first bit of trouble that comes along will sweep it away. So it's an important fight you're undertaking, Matt, and I really wish you every success. And I hope that you'll come back and talk to me again, maybe on a day with happier news.
Thanks, David. Yeah, I mean, we're going to continue to fight, and yeah, I just hope we can get through these, like you say, the obstacles that they're placing in front of us now, like we've done before, and yeah, get this into a court where it's not perfect, the system, but I'm hoping that if we can actually get it into court, it's where it should be. It's where my brother's first inquest, it should have really looked at the evidence and should have flagged there is no evidence, there is no inquiry here. But sadly they didn't, and she retired 6 months later. And I think that's partly the reason why I think it was held when it was held. It was just tick the box, rubber stamp the American version of stuff, official narrative, and that was it.
Just before we leave, are you receiving support and interest from America on this? And is there anything equivalent happening in the States?
They don't have the same mechanism like we do in terms of an inquest, and certainly the mechanism to reopen an investigation into someone's death. Yeah, I mean, sure. The actual application itself had support of victim family members from the US. So, I mean, there is support out there, and a lot of the people who have donated so far, from what I can tell, are all across the world, but a lot are from the US. I mean, after all, the crime did happen on their soil, and I think a lot of people are still very interested in getting to the truth of what happened that day. And this is a small part of what happened. They shouldn't be so scared of it, but like we said earlier, it's that foot in the door. I think they're petrified of anyone actually challenging the official narrative in a court of law, and so they're going to try and do everything they can. Doesn't mean we can't win, doesn't mean it's impossible, it's just hard. Gotta keep fighting.
Matt, thank you very much for your time. It's been lovely talking to you. Until next time, thank you.
Cheers, David.